Good morning, ladies and gentlemen. We're here in the Franklin Circuit Court on Monday, October 25th, 2021 for our civil motion docket. And we've got several matters that need to be heard here in Division 1. We're
should be good to go.
okay. All right, we're having some technical difficulties, but I'm hoping that that's been resolved. So we're still learning as we go here on our remote motion hour. So let's go ahead and we'll call the docket in the order that I've got it here on the docket sheet. The first one we have is 21 CI 324, Commonwealth Credit Union versus Christopher Royster.
Chris Hill for the plaintiff, Your Honor. That's a motion for judgment and order of sale in a real estate foreclosure case.
Okay.
It was previously before this court and you entered an order holding it in abeyance for 90 days to see if something could be worked out. And so far, nothing's been worked out.
Okay. All right. And it looks like there hasn't really been any objection filed that would state any valid reason then to delay any further. So the court will grant the plaintiff's motion for a judgment order of sale. And I'll sign the orders that you tendered, Mr. Hill. Okay.
Thank you very much.
All right. Okay, next we've got 21 CI 461, which is Council for Better Education versus Johnson. I think we're going to need to have some discussion in that case, so I'm going to hold that to the end of the docket and we'll come back to that. And the next case we have is 21 CI 537, Frankfurt Shell Food Mart versus Racetrack Petroleum.
Morning, Judge Scott Schutte on behalf of Frankfurt Shell.
Morning, Your Honor. Barry Stills on behalf of Franklin County Planning and Zoning and Building Code Enforcement.
Okay.
Morning. Go ahead, Charlie.
Charlie Jones here, Judge, for the defendant, Racetrack.
Your Honor, Ed Logan here for the Transportation Cabinet.
Your Honor, we had filed a motion for a hearing date. Mr. Stills' client has a motion to dismiss on as well.
Yeah.
Our thought and assumption was you had wanted all this to be heard at a special hearing once all the parties are before the court. We believe we have everyone in front of the court now, and we're looking for a special hearing date.
Your Honor, Barry Stills, with regard to our motion to dismiss, the special hearing date appears to be more aimed at the defendant and the Transportation Cabinet, not appears, it is.
Yeah.
And the Franklin County Planning and Zoning and Building Code Enforcement really has no dog in that fight, and there's no action or relief sought against them. I don't want to have to go to the expense of preparing and briefing a injunctive motion, Your Honor, if there's nothing to really be had.
Okay. Well, let me just say, obviously, we are going to have a hearing that's going to be more extensive on the injunctive relief portion. I understand Franklin County's planning and zoning officials have a motion to dismiss, which, I mean, that's a legal issue. We could have that submitted on the record. I think we might want to have some additional argument on that. So what I'm inclined to do is to set this for a hearing outside of motion hour. We'll have an argument on the Planning and Zoning Commission's motion to dismiss, and then we'll have an evidentiary hearing on the injunctive relief motion. And I'll say with regard, Mr. Stilts, with regard to the Franklin County Planning and Zoning, my concern and my interest is going to be whether whether there's anybody in Franklin County government from the planning and zoning or perspective or otherwise who, has any involvement in the decision with regard to the ingress and egress here on this exit off the interstate, that, it's alleged it creates a dangerous condition for the public. And it seems to me like there ought to be somebody in Franklin County government that would have some jurisdiction or some interest in that. And, maybe there's not, but if there is, I want that person to be available to testify. And if there's not, I guess I would like to have somebody available to testify to explain why it's none of Franklin County planning and zoning's business. Because it does seem to me like it is the kind of thing that ought to be considered in the planning and zoning process. So, I don't anticipate Franklin County planning and zoning having to put on a lot of evidence in this, but I do think somebody ought to explain to the court why Franklin County planning and zoning is taking the position it's none of their business and they have nothing to do with it. Maybe that's true, but again, I think somebody probably ought to explain for the record.
That's fine, Your Honor. I think we've laid it out in our motion to dismiss why it's the transportation cabinet's business, and
Right.
unfortunately they trump us. So
Yeah, but there's somebody, it seems like somebody ought to be looking out for the interest of the citizens of Franklin County in this process. And, and again, maybe there's no issue there, but I don't understand it enough to say that right now. And I would like to have, I just think we need to thrash this out probably at a hearing. So
that's fine, Your Honor. If we could have the motion to dismiss be heard first.
Yeah, absolutely. Yeah, absolutely.
That's fine with us as well, Your Honor.
That's no problem. And I think,
and Your Honor, I was not planning on not participating in that hearing. They can certainly subpoena whoever they wanted to if we weren't a party. So that's
right. Absolutely. That may be, there may be an employee who will testify as a witness and so forth. So,
Judge Shepard.
Yes.
If I may, Judge, this is Charlie Jones. Judge, if we can, we will also are ready to tender and file another dispositive motion. So if the court's considering these on separate dates or hearing a later date, I would ask the court to consider setting a time frame for any dispositive motions to be filed, responses, and then the hearing date.
Yeah. I will say, we've kind of had false starts now on an injunctive relief hearing a couple of times. And I don't know what the time frame for Mr. Jones, for your client's plans to open up this facility and to put this exit and entrance into use. So,
well, I think we previously told the court it would be after the first of the year before it would open up. So surely in the month of November, these matters can be heard.
Yeah. Okay. All right. Well, let me, I'm going to go ahead and schedule this for a hearing. I don't know that we need to wait for dispositive motions to be filed and briefed to have the hearing on injunctive relief. And I think we probably need to have that, I think within the next, within the next, 20 days or so. So I'm going to go ahead and what we'll do is we'll schedule this. I want you all to have your calendars ready, and my assistant will be following up with you to set a hearing date sometime within the next, I would say, 2 weeks. And then we'll just set the injunctive relief for a hearing, and then we'll figure out where to go from there. And obviously anybody can file a dispositive motion if they think the record justifies that.
If you would also set the motion to, at least our motion to dismiss for hearing at that time.
Sure. Yeah, we'll hear the motion, all pending motions and the motion, including the motion for injunctive relief and the Franklin County motion to dismiss. And And I guess, let me ask Mr. Logan, on behalf of the Transportation Cabinet. Who is the responsible official at the Transportation Cabinet who oversees this?
That, excuse me, that will be the chief district engineer in Louisville. We had planned to call him. That was the only caveat I had to setting a hearing is I
Yeah,
don't have his schedule available right now, and I'd want to check with him to make certain.
right. Okay.
Logan,
All right. Well, obviously, I'm going to want to hear from him. So I'll ask Mr. Logan to go ahead and check with the chief district engineer in Louisville and make sure he's available for a hearing. Again, it's my intent to set this within the next couple of weeks. So we need to get our calendars out, and my assistant will follow up with you all with regard to setting a firm date, and we'll take it from there. But I do want to hear, obviously, from the chief district engineer of the Department of Highways from the Louisville district, anybody from Franklin County Planning and Zoning who has knowledge about these issues, and then I guess whoever else the plaintiffs want to subpoena or provide testimony from. So we do have a lot of issues to thrash through. So we'll set this for a hearing in the next couple of weeks and see if we can't thrash it out. Okay.
thank you, Judge.
Yeah,
Thank you, Judge.
Okay. Thank you all.
thank you.
All right. Our next case is number 21 CI 629, April O'Day and others versus the Kentucky Department of or Justice and Public Safety Cabinet and the Department of Criminal Justice Training. So looks like we've got a motion here with regard to discovery. So I'll be glad to hear you all out on that.
Yes, sir.
Okay, Mr. Clay. Mr. Clay's muted himself, I think.
Your Honor, is there a motion? You want me, I'll be happy to go first if you like.
Well, who wants to speak for the defendants? Let's speak up.
Hey, good morning, Your Honor. This is Nick
All right.
Nick Birkenhauer. I represent the defendants in this case, and my colleague, Aaron Shaughnessy, is also on the call this morning as well.
Good morning, Your Honor.
Okay,
And Your Honor, this is our motion to set the order of depositions in this matter. As indicated in our motion, counsel has been unable to agree on that order. And as set forth in our motion, it's our position that it's the normal custom for the plaintiff's depositions to be taken first in a case, particularly an employment case such as this. As indicated in the Kentucky Practice Series annotation to Rule 2604 cited in our motion, defendants should have the ability to hear the nature of the plaintiff's specific allegations, before being required to submit the depositions themselves. And certainly, Your Honor, this mirrors the order of evidence at trial. So it's a rational and customary way to approach the order of depositions in a civil matter.
okay. All right. Mr. Birkenhauer is citing his law partner's treatise here to support his argument. So I will, but I understand the issue there, and certainly it is a valid point. So, Mr. Clay, what's plaintiff's position?
Your Honor, we asked for deposition dates for the defendants back on October the 7th. And our response was regarding, this is email traffic. Regarding the order of depositions, we will take the depositions of the plaintiffs prior to the depositions of the defendant. I responded saying that I don't think that's appropriate under Rule 2604.
Recording in progress.
And I know I don't have to educate the court on 2604.
Okay, good morning. It's 25th day of October.
I'm in two places at once, Your Honor. I apologize.
Yeah, okay. I hear my
Yeah, Frankfurt.
my colleague coming through on the other.
Yes, sir.
Mr.
So,
Clay.
and he also responded, party defendants have a right to hear what the party plaintiffs have to say about their case and to have full knowledge of the facts and allegations at issue prior to themselves being required to submit to a deposition. That flies in the express language of Rule 2604, Your Honor, and I've only been doing this going on 48 years. I'm not aware of any practice that says that the plaintiffs have to be deposed first. And of all the cases I've been involved with, of any situation, the defendants ought to know what this case is about. One of the plaintiffs in this lawsuit, Tina Moss, is the HR director for DOCJT. She generated literally hundreds of emails to people who are named as defendants in this action, expressing her concerns not only about the way she was being treated, but about the way that certain other of the plaintiffs, specifically Ashley Percy and April O'Day, were being treated by John Schwartz, who is one of the executives in DOCJT, referring to these two ladies as bitches. And then DOCJT did an or actually the Justice Cabinet did an investigation, and Cat Reed interviewed Mr. Schwartz. He lied about referring to these women as bitches. And then when Mr. Kubala, another named defendant, outed him about what he had said, Mr. Schwartz came around and admitted he had in fact referred to Miss Percy and April O'Day as bitches. So there's
Well,
also
we don't need to try the case here, Mr. Clay. So
yes, sir.
I guess it's a little frustrating that y'all can't agree on deposition dates. So what are the reasons why your plaintiffs need to depose the defendants before they're deposed?
Because we think there's an issue with credibility, Your Honor, and we'd like an opportunity to explore that in some of the representations they've made through the investigator and other officials in the Justice and Public Safety Cabinet.
Okay, explain that. Why would that be diminished if your clients are deposed first?
I think it would expose some facts that perhaps they may not be aware of at this point, but I'll leave this to the court's discretion. Just whatever. I know this is not your first rodeo with this.
Right. I mean, everybody's going to have to be deposed, and I'm going to expect everybody to, make a full record here and to get all the facts out there, which is what discovery is all about. So, let me, you all have briefed this. I'm going to review that, and I'll get an order out that will just give you all the court's directions as to how we need to schedule these things and get them going, because, obviously we need to get the depositions taken and then move on to, get this case ready to get resolved, hopefully. So, I don't think we don't have a scheduling order in place in this case either, do we?
No, sir.
No, sir.
It's a new case. So, okay. Well, I'm gonna look at the record again, and I'll give you all an order with the court's ruling as to the order of depositions. And then I'm going to expect you all to meet and confer and submit a scheduling order that will get the case on track to be fully complete to complete discovery and any dispositive motions, and we'll move it toward resolution and a trial. So, but I'll have you all in order here within the next day or two on the order of depositions. Okay.
Thank you, sir.
Thank you, Judge.
Okay. Thank you. Okay, then I think that's all of the other cases that we have. We can go back now. Before we go back to Counsel for Better Education against Johnson, let me ask, are there any other motions that I missed? Is anybody else on the call that has a matter that needs to be heard before we go to the Council on Better Education case? Okay, apparently not. So let's now go back to number 21 CI 461. And that's Council for Better Education versus Johnson. And we've got a couple of motions before the court following the court's entry of judgment. And let me say the court has obviously misunderestimated the potential for the court's ruling to be misconstrued in a couple of fashions, a couple of ways. So we're going to address that. So let me reiterate that the court's ruling does not apply in any way, shape, or form to sections 1 through 4 of the bill. I will, spell that out again. And obviously, the court did use shorthand, I guess, in referring to House Bill 563 without specifically specifying that the court's reference to House Bill 563 in the ruling was a reference to sections 5 through 17 of the bill, and again has nothing to do with sections 1 through 4. And apparently, the Department of Education has, apparently misconstrued the court's ruling in that respect, and I'll straighten that out. So let me first turn to Mr. Owsley, who's filed a motion asking the court to clarify that. And Mr. Owsley, I'll say, as much as I enjoy having you practice in this court, I'm inclined to, with that understanding, that I'm going to, again, set that out in terms that I think even the most intransigent bureaucrat can understand. With that understanding, I'm going to probably deny the motion to enter unless there's some other reason why your clients are seeking intervention.
No, Your Honor, I'll just say that I think Regina Jackson's on the call, as was Tim Crawford, and we filed this on behalf of 6 intervening school districts. But the reason for it was we had understood that the Council for Better Education was going to file a motion to clarify. And when they didn't, we felt we needed to file the motion. Subsequently, the same day, night, the Attorney General filed its motion, and
they've raised that issue too.
Agreed with us. So I would agree, Your Honor. That was the only reason for our intervention, was to clarify that issue, and you made it clear your plan to do that.
Yeah. Okay. And again, I think we can straighten that out in short order, and the court will do that. And so the court, with that understanding, I'm going to deny the motion to intervene. But again, I appreciate Mr. Ashley bringing this to the court's attention with regard to the way the Department of Education has construed the bill, or the court's ruling. Obviously, that's an issue that does need to be further addressed, and I will do that. And obviously, the Attorney General has also raised, and so the Attorney General has also raised a couple of other issues, and I'll be glad to hear them on that. Mr. Thacker, are you going to be speaking for the Attorney General, or?
I am.
Okay.
So, Your Honor, yeah, again, we did raise the sections 1 through 4 issue. Glad that's resolved. We really raised one other issue for several grounds, and that is the court's, it's probably paragraph 6 of the court's order, which reserves for apparently additional proceedings.
Yeah, and let me interrupt you, Mr. Thacker, because again, I think that's something that maybe I wasn't clear enough about, and I don't know if this makes any difference in your all's concerns here, but I will just share the court's thinking, which maybe was not very artfully conveyed. I think with regard to the other issues that are in the case beyond the issues on Section 59 and Section 184 that the court granted summary judgment on, I think with regard to the other issues, there are the record is not fully developed enough for the court to grant a summary judgment. So I denied the summary judgment motions on both sides. And but I will say that, the court does not anticipate and will not conduct any further proceedings with the understanding the court's ruling on Section 59 and Section 184 is going to be appealed. So the court is not going to conduct any additional hearings or proceedings, and the court's intent is to hold the remaining issues in abeyance pending whatever appeal is taken from the court's ruling ending the summary judgment on section 59 and section 184. You know, if court's ruling is upheld, there will be nothing else to be heard, and the case will be over. And if court's ruling is reversed, I think there are additional issues that would require some additional work in the trial court. So that's really all the court was thinking with regard to that. And I understand there's going to be an appeal. So.
And Your Honor, you know, largely our concern is about the appeal, and to make sure that obviously to the extent that, with due respect, we disagree with the court's determination that there are factual issues as to any of these arguments. Also, just as a practical matter, as Your Honor knows, that an appellate court may affirm on any grounds, and so we fully would anticipate that in response to our appeal, that the plaintiffs might argue, and probably would argue, that to the appellate court that, well, even if the court below was wrong on 59-184, you can affirm on these other issues. So our concern is that the record be clear that to the extent there are legal issues that the parties have raised, facial challenges, that all those are in the ballgame. And so we think the entire order should be final and appealable to you know, take away that ambiguity.
Okay. Well, you know, I mean, I understand that, I will take a look at that. I will say that I don't know how, you know, the denial of summary judgment, I don't know how I could make that final and appealable when, you know, when really all it is the denial of summary judgment. And I don't know. I don't think that's an appealable order, but I do understand to the extent that there's a facial challenge that, you know, people may be asserting arguments on maybe on appellate review. So I'll take a look at that, and I'm not quite sure how to handle it. So let me ask, is there anybody that from the plaintiffs that wants to weigh in on that?
Sure, Your Honor. Eric Harrington for the plaintiffs. A couple of points. First, we obviously agree with Your Honor that you have authority to do this. I think that was one of the issues that was put in contention by the Attorney General. I think it's clear that you have the authority to grant summary judgment on some claims and hold others as the claims you granted summary judgment on our appeal. We still obviously maintain that we are entitled to summary judgment as a matter of law on the other claims. And we also agree with Your Honor that it's hard to imagine the mechanism to get those up absent granting summary judgment in favor of one of the parties. And obviously we would believe that we are entitled to summary judgment on those claims.
Okay. All right. Well, you know, and I understand maybe both sides may disagree with the court as to whether the remaining claims are summary judgment material. So I'll let you all figure that out, and I'll go ahead and issue an order today. I will. I want to review Mr. Thacker's arguments and concerns that he's raised here today. But again, I don't think, again, in the court's mind, there are things with regard to, for example, the claim that the legislation violates Section 183 of the Kentucky Constitution. I do not see how any court can rule on the validity of that claim without having more information in the record than what we've got in this record. So, you know, again, that's something that maybe both sides disagree with the court on, but I will take a look at those arguments and we'll enter an order in the next couple of days that will the court will address that, and then obviously you all can take it up to the appellate courts and see what they think about it. But I'll go ahead and get an order out then in the next couple of days to address these issues. I will most definitely address the issue that Mr. Owsley and the Attorney General have raised with regard to the scope of the court's ruling and to does not involve sections 1 through 4 of the bill in any way, shape, or form. And then with regard to the finality of the whole order and the court's and the other issues that were presented in the summary judgment motion, I'm going to take another look at that and review the Attorney General's concerns, and I'll again issue an order. Again, at this point, I'm kind of unconvinced that the court can make a finality determination on a ruling that is by its very nature not final, but with regard to the other claims. But I understand the concerns Mr. Thacker has voiced, and I want to take a look at those. And I'll get an order out, and then you all can move on to the Court of Appeals and or the Supreme Court, and we'll let them figure it out. So,
Your Honor, if I may.
Anything else? Yes, Mr. Harrington.
Yeah, if I may, you raised the section 183 question. And I want to be clear on a couple of things. One is, in our response to the Attorney General's motion, we agree with Your Honor that the 183 adequacy claim would require factual development. It's why we didn't move for summary judgment on that. But the 183 discrimination claim, which Your Honor, your opinion artfully, I think, addresses, we do think that 183 claim could be addressed. And we think you almost did in the original opinion. Okay. And then the Fannin issue, we think that can be addressed as well.
Okay. All right. Well, I'll take that into consideration and review the record again. Then I'll get you all in order very soon, and wish everybody luck in their trek through the appellate courts. Okay.
Thank you, Your Honor.
Thank you.
All right. Thank you all very much. And I think with that, that completes our docket for the morning and motion hour docket.